I'm Susan Curry, and I have the honor of serving as the interim director currently. I want to thank you for coming to our program tonight. As you may know, yesterday, September 17th, was officially Constitution Day. Earlier this year in June, the library and the Tompkins County historian, our own Carol Cammon, who's here, hosted a public reading, yay, hosted a public reading of the U.S. Constitution. From that reading, this program series on the U.S. Constitution was developed by the county historian, retired Cornell law professor and author Stephen Yale Lair, and the Tompkins County Public Library. We're very excited to offer this program series. The series of programs is focused on critical aspects of the U.S. Constitution and citizenship. We're grateful to Professor Yale Lair and our county historian for helping to organize and present the program. I'd also like to thank our communications manager, Brian Sasser, our local history librarian, Megan Malloy, our administrative manager, Mary McCann, for their assistance in presenting these programs. To quote our county historian, the U.S. Constitution is a beautiful but complex document. Today is at the center of controversy and challenges. She urges us to attend programs to discuss the Bill of Rights, voting, citizenship, and immigration with experts and our neighbors who protect our voting rights, and those who aid immigrants and teach about citizenship. It's important to know our rights and act to preserve them. And Stephen Yale Lair, who is the retired professor of immigration law at Cornell Law School, says it's more important than ever for you to know your constitutional rights. This free series will help you do that. Tonight's program is focused on the Bill of Rights, and we are very honored to have Michael Dorf, the Robert S. Stevens Professor of Law at Cornell University, and the co-author of a book on reading the Constitution, to present and lead the discussion. And with that, I'll turn it over to Michael.
This evening. As you are undoubtedly aware, the Bill of Rights, the Constitution, and much of our legal order is being tested at the moment. And I'm sure there will be lots of questions and comments about that, and I want to leave plenty of time for discussion. What I thought I would do with my introductory time is to give you a kind of brief historical overview of what the Bill of Rights is, how we got it, how it's changed over the years, and then leave the sort of future with the question mark part for mostly for Q&A. All right, so yesterday, it's true, was Constitution Day. That is a date chosen by Congress in the 1950s. More recently, Senator Robert Byrd, you may remember from West Virginia, pushed to have a bill put through Congress, which did get through about 15, 20 years ago, mandating that educational institutions that are federally funded do something to celebrate or at least mark Constitution Day. I thought that was a little ironic given the First Amendment, but never mind. The date actually, yesterday's date, September 17th, that marks the signing of the original Constitution in 1787, which is it's a somewhat unusual date to pick for Constitution Day because the signing didn't really do anything. The Constitution was sort of illegal under the then existing legal regime. Under the Articles of Confederation, it required unanimity among the states to amend the Articles. But the Constitution, sort of by fiat, said that, well, this will become effective upon ratification by at least 9 states. And so you might think that the right day to celebrate would be upon the 9th ratification rather than upon the signing, but they chose September 17th. It fits well into the calendar year for schools, so there we are. The original, so let me tell you a little bit about what I'm going to talk about. Okay, so first I'm going to talk about adoption of the Constitution. Then I'm going to fast forward to the end of the Civil War. and talk about Reconstruction and incorporation. Incorporation is the process by which the original Constitution, which is only applicable to the federal government, is made applicable to the states and local governments. I'm going to talk a little bit about the amendment process, how we get amendments, what they've done, and so forth. I'll give us a case study about what may or may not be part of the Constitution as the 28th Amendment, and then we'll move on to discussion. By the way, although I want to save discussion for the end, if you have like a question that you need me to clarify something, please feel free to raise your hand while I'm going and interrupt. Okay, so as I mentioned, the original Constitution, Constitution Day, it doesn't contain a Bill of Rights, at least not a big Bill of Rights. And Thomas Jefferson, who is not at the Constitutional Convention, he's in France serving as the US ambassador there, gets a copy of the Constitution before it's been ratified, and he sends a letter to, excuse me, to his buddy and fellow Virginian, James Madison, complaining about this. He says, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference." Seems like a good point. And so you might wonder, why didn't they include one? Well, it turns out Jefferson wasn't the only person around with an opinion. Around the same period, shortly thereafter, Alexander Hamilton writes in Federalist number 84, which, as you may recall, the Federalist Papers are a series of pamphlets addressed to the citizens of New York urging ratification of the Constitution. They're written principally by Madison and Hamilton. John Jay wrote a few of them, but then he got sick, so he didn't do much of the rest. But we know which ones Hamilton wrote and which ones Madison wrote for the most part. This is Hamilton. And Hamilton says, "Bills of Rights, in the sense and in the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers which are not granted, and on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done, which is there is no power to do?" So let me see if I can unpack that for you a little bit. So if you go back and read the original Constitution, I have a copy right here in case you need one, you'll see that Article 1, which sets up Congress, begins by saying all legislative powers herein granted are vested in a Congress. And then it proceeds to have a bunch of stuff about how you elect Congress and so forth, until you get to Article 1, Section 8, which is most of the powers of Congress with which we are familiar. The power to raise and support armies, the power to regulate interstate and foreign commerce, the power to tax, the power to spend, and so forth. And then at the end, there is the power to make laws necessary and proper to carry into execution the other powers. But the theory of enumeration, as it was generally understood, I'll add a footnote, which I'll get to in a moment, but the theory of enumeration was that by listing those powers, the framers meant, and the ratifiers agreed, that those were the only powers of the government. So if something was not a listed power, it was assumed not to reside in the federal government. And so Hamilton is articulating what I think was the standard view at the Constitutional Convention, which is you don't need a Bill of Rights because the way in which the federal government is limited is by only giving it certain powers. And so what does he mean by it would be dangerous? Well, it suggests, I think Hamilton is worried that if you have a right to freedom of speech, you might think, oh, I guess those powers otherwise would have included the power to infringe speech. Now you might say, okay, well that's no big deal because you just include the freedom of speech, then you don't have that inference. But Hamilton is suggesting that the Bill of Rights will inevitably be incomplete, and so there will be some things that are not prohibited by a Bill of Rights that will then be assumed to be granted to Congress, and in this way, the Bill of Rights will indirectly enhance the power of the federal government, which is what they're worried about. So that's Hamilton's response to Jefferson. Well, as we know, in the court of public opinion, well, actually, before we get to that, I want to say something else, which I forgot I had this slide in here. All right. You might wonder, actually, if you're reading through your Constitution, wait, is it really true that the original Constitution contains no Bill of Rights? It does actually contain some rights. So if you look in Article 1, Article 3, Section 2, right, there's the right to trial by jury in criminal cases. It's right there in the original Constitution. Anything with an article means part of the original Constitution. Article 1, Section 9, privilege of the writ of habeas corpus can't be suspended, so there's a right to habeas corpus. Also Article 1, Section 9, no bill of attainder or ex post facto law shall be passed. Who knows what a bill of attainder is other than my two former students in here? Yes, sir.
Well, I just happened to be reading about England in the 16th century, and Thomas Cromwell was getting bills of attainder passed through Parliament, and they took land away from nobles and other people. It was usually used, in that time, it was used to help the king get what he wanted.
Yeah, so a bill of attainder is a law passed by the legislature that singles out one or more individuals for punishment. That's how it's been understood. That was how it was understood in the colonial side by the time of the adoption of the Constitution, right? So the idea is that if you're going to put somebody in prison for something they did, you got to give them a trial. You can't have trial by legislature because the legislature is going to be subject to political pressure rather than to be judging on the facts and the law. I think we know what an ex post facto law is, right? That's a law that makes something a crime after the fact. So there are actually provisions in the original Constitution that function as a kind of miniature Bill of Rights, but Jefferson is correct that a lot of other things that you might think belong in a Bill of Rights are not contained in the original Constitution. And so in the court of public opinion, in the debate over the ratification, Jefferson wins. And what do I mean by that? Another one out. This, no religious tests, right? That's in the original Constitution. So they can't require that you express, a certain religion in order to have a government job. Yes?
Well, what you said at the beginning is they enumerated what the Congress could do.
Yeah.
Meaning that anything else they couldn't do. So I can see that the Bill of Rights thing, if they have enumerated some rights, then you could also assume that anything they didn't enumerate would be there.
On the right side. Yeah, you could assume that. That's why they wrote, I'll get to that in just a second. It's a great point. Jefferson thought of that.
I can imagine.
Yeah. Okay, so Jefferson wins the argument. And what I mean by that is that a number of the large states, states without which the Union wasn't going to survive, ultimately ratify the Constitution, but only after the Federalists, right, the Federalists are the ones proposing the Constitution, promise that in exchange for ratification, they will take up the business of adding a Bill of Rights. Right, so they promise that to the Anti-Federalists, and they keep their promise. Now, how do they deal with this problem of, you enumerate some rights, does that mean there are no other rights? We'll get to that in a moment. Before we do, though, I'm going to tell you a little bit about what they have. So it falls first to the House of Representatives to draft a Bill of Rights. And lots of proposals come in from the states, many of them duplicative of one another. But the states are able to propose these amendments partly because in the previous decade, sometimes called the critical period by American historians, right? Every state, with the exception of Rhode Island, had adopted a new constitution. If we have time and you're curious, you can ask me about Rhode Island later. I was just in Rhode Island last weekend, lovely place, but it was weird constitutionally speaking. Out of all of these proposals, Madison puts together a list of 20 that he advances to the floor of the House of Representatives. The House passes 17 of those. The Senate takes those 17, rejects 5 of them, and agrees on 12 of them. They then send those 12 out to the people, right? And the states ratify numbers 3 through 12, which we now understand as numbers 1 through 10. Now, so whenever anybody says, the reason the First Amendment is first is because it's the most important, it was actually third originally. And maybe it was even further down the list on Madison's original list. But in any event, that's how we get those provisions. And these 10 are collectively sometimes called the Bill of Rights, although my own view is that only the first 9 should be considered the Bill of Rights, because the 10th Amendment, which reserves powers not delegated to the United States, to the states or the people, is not a provision about individual rights. It's a provision, it's essentially redundant with the Hamiltonian argument I gave you a moment ago. Federal government only has the powers that are listed. Yes, sir?
Give us some of the missing ones that you found interesting.
Sure. So the question is, what are the missing ones? So I'll tell you about, I don't actually know much about the 5 that got knocked out in the Senate, but I'll tell you about 2 of them. And one of the 2 I'm going to forestall most of our discussion until later. So the original First Amendment was a proposal to cap the number of people who could be in a House district at, I believe, 40,000. Right? Madison's worry, and this was shared by, I guess, Congress as a whole, was that if any representative was representing too large a multitude, they would be unable to really be in touch with the people, so they wanted to cap it. The people at the time reject this basically because there's a prescience among the ratifying states that was lacking in the drafters, which is the population of this country is going to grow enormously over time, and if you do that, the legislature will become enormous. Now, I don't know that this was necessarily the right move. The Parliament of India, I believe, has over 5,000 members, and so it's possible, but it's virtually impossible to function as a deliberative body in that large a group. Okay, so the first 10 or 9 are collectively called the Bill of Rights, and here I'm going to list them all just so a little reminder, right? So there's the First Amendment contains speech, press, assembly, free exercise, and establishment of religion. Actually, no establishment of religion. Second Amendment is a right to bear arms. Third is the prohibition on quartering of soldiers in private homes during peacetime. Fourth Amendment requires, forbids warrants from issuing except on probable cause, and particularity is to be searched, and prohibits unreasonable searches and seizures. The Fifth Amendment contains a hodgepodge, contains the right to a trial to an indictment by a grand jury. That's why in federal court you get a right to a grand jury. Prohibition against double jeopardy, right against self-incrimination, the due process clause, and the takings clause, which says if the government takes your property by eminent domain or otherwise, they've got to pay you fair market value. Okay, Sixth Amendment contains a bunch of criminal procedure protections. It's a right to a speedy trial, a right to a jury trial. You're probably wondering, why did they include the jury trial right here when I told you a couple slides ago that it was already included in Article 3? The answer, I think, is they forgot. You know, it had been a couple of years. Then there's the right of the criminal accused to be confronted with the witnesses against them. A right to compulsory process. That means if you are accused of crime and you need to get a witness to testify and they don't want to testify, you can have the court assist you. And most importantly, perhaps the right to counsel. I say that as somebody whose job depends on having a lot of jobs for lawyers. The Seventh Amendment is a right to a civil jury trial. So that's in a civil case, right, where somebody's suing for money damages or an injunction as opposed to a criminal case. Eighth Amendment prohibits cruel and unusual punishments and excessive fines. And finally, we come to the answer to your question, right? What did they do to avoid the inference that this list of rights implies that there are no other rights? The Ninth Amendment specifically forbids that. It says the enumeration in this Constitution of certain rights shall not be construed to deny or disparage the existence of other rights not enumerated. So it suggests that there are other rights out there. It's kind of like, you know, you have a list, right? And at the end of the list you say, and anything else similar. So that's what the Ninth Amendment does. And then the 10th Amendment, as I mentioned, is the reserved powers of the states or the people. Yes?
Combining establishment of religion with freedom of speech is the implication that the expression of religion is a form of speech, or are they just putting the shopping list together?
Yeah, it's a good question. I think it's a little bit of, yeah, the question is whether in grouping the speech and press rights with the rights relating to religion, are they suggesting that religion is a kind of speech, or is it just a kind of laundry list, and these happen to be together? And I think the answer is it's a little bit of both. Certainly the Fifth Amendment is a kind of hodgepodge. There's thematic unity to each of the amendments, but there's also a little bit of hodgepodginess. But I should say that in recent years, the US Supreme Court has tended to treat speech and religion as sort of interrelated and interesting, and in my view, in sometimes pernicious ways. So that if you think about some of the most contentious cases and the cases that have gotten a lot of the most publicity in recent years, some of them that seem to be about religion are officially only about speech. So think about, there's a case a couple of years ago in the Supreme Court called 303 Creative against Olenis. This is about this web designer in Colorado who said she didn't want to create a website for a same-sex couple's marriage. And her objection was rooted in her religious views, but the Supreme Court heard the case entirely as a case about freedom of speech, which is in some ways broader, but in other ways, you know, it means it's not really about what the case seems like it's about. Okay. Yes, another question. Yeah, go ahead.
Cruel and unusual punishments. I mean, I can imagine that's the idea of what that is has changed significantly over time. Can you talk about that?
Yeah, sure. So there's a case from the 1950s called Trope against Dulles, in which the Supreme Court has this very famous line. It says that to define what counts as a cruel and unusual punishment, we don't simply look at those punishments that were considered cruel in the framers' time. There's pretty good evidence that in the time of the adoption of the Constitution, late 18th century, things like cropping off somebody's ears as a punishment for crime, that was considered cruel and unusual punishment. Putting them in the stocks, you know, like you see in colonial Williamsburg, that was sort of an edge case. But they go beyond that in this Trupp case, and the court says that the Eighth Amendment forbids those punishments, I'm going to see if I can get the quotation exactly, that are inconsistent with the, quote, evolving standards of decency that mark the progress of an evolving civilization. Now, don't get your hopes up. So in the early 1970s, a number of successful challenges were brought to the death penalty, saying that the death penalty is cruel and unusual punishment. Part of the pushback against that was an express invocation of the Fifth Amendment, right? Because the Fifth Amendment has two provisions that seem to suggest that the Constitution is okay with the death penalty. One is the Due Process Clause. No person shall be deprived of life, liberty, or property without due process of law. So that suggests you can be deprived of life with due process of law. And the Double Jeopardy Clause says that no person shall be twice put in jeopardy of life or limb. So the argument was made in favor of the constitutionality of capital punishment that actually it's expressly contemplated by the Constitution. Now that argument doesn't prevail in a case called Furman against Georgia in, I believe it's 1976 or 1974, whatever, I could be off by a couple years. In the early 70s, the Supreme Court invalidates every death penalty in the country under the Cruel and Unusual Punishments Clause, but does not say that the death penalty is per se constitutional. What the court says is the way it's being administered is so arbitrary as to be cruel. Now, I think it's the justices who wrote that expected that would be the end of the death penalty, but it turns out that what happened was most of the states that had a death penalty went and reenacted their death penalty and changed it to conform to what the Supreme Court had said. And then in a couple of cases a few years later, a case called Gregg against Georgia is the leading one, the Supreme Court upheld those new statutes. And so that's why we've continued to have a death penalty, although subsequent cases using this evolving standards of decency standard have invalidated specific practices. So there were two cases in the early 2000s, a case called Roper against Simmons and Atkins against Virginia, that invalidated the death penalty for anybody who committed their crime while under the age of 18, and also invalidated the death penalty for anybody who committed the crime and was intellectually disabled. There are other cases involving challenges to methods of execution. Those challenges have mostly failed. That is, the Supreme Court has allowed lethal injection, it's allowed hanging, and so forth. And I have some reason to worry that the Supreme Court, as currently constituted, might back off of the entire line of decisions, beginning with Trop against Dulles, and say, actually, what's cruel and unusual now is what was cruel and unusual by the framers because they're moving in that direction in some other areas of the law. Yes, follow up.
Yes. So is this usually applied to judgments that actually happen at trial, or what happens if somebody's imprisoned and they're kept in solitary or whatever?
Right, so great question. What counts as cruel and unusual punishment? So first of all, it has to be punishment. So there are cases, leading case, a case called Bell against Wolfish, in which people who are pretrial detainees object to the conditions in which they're being held in jail. And the Supreme Court says, well, you actually can't proceed under the Eighth Amendment because this isn't punishment, but it's okay because you have a due process claim. So that's sort of just a technical lawyer's move. I will say that in general, the court has applied the cruel and unusual punishments clause to conditions of confinement as well, even if they're not part of the sentence. Justice Clarence Thomas has written in a couple of dissents that he thinks that, the Eighth Amendment only applies to something that is literally part of the sentence, but he hasn't gotten anybody to go along with him on that one. Okay. So those are the first 10, the only 10. That's the Bill of Rights. And now we'll move on to a little bit of more history. So in the early days of the Republic, people notice that the way that the Bill of Rights is written seems to state rights in the abstract, right? Not all of it, right? So for example, the First Amendment says, Congress shall make no law respecting an establishment of religion or infringing the free exercise thereof, abridging the free exercise thereof, or the free, blah, blah, blah. So Congress, that's a federal body. But other provisions, right, are just sort of generic and seem like they could apply not just to the federal government, but to any level of government. And so in this case, Barron against Mayor and City Council of Baltimore, somebody whose land was appropriated sued Baltimore, which had taken the land, under the Fifth Amendment's Takings Clause, which says, neither shall private property be taken for public use except upon payment of just compensation. And he says, doesn't say who's taking it, so that's a prohibition. Right? There's the exact language. I got it pretty good. And the court hears that argument and says, no. Chief Justice John Marshall, the third but sort of leading Chief Justice of the early Republic, writes for the court that the Bill of Rights imposes limits on the federal government, not the states. Everybody understood that was what it was about. After all, your rights against your state government, and by extension any local government, come from your state constitution, not from the federal constitution. So now there are a few provisions in the original Constitution that do impose rights against the states. They're found in Article 1, Section 10. So just as there's an ex post facto clause that forbids the federal government from enacting ex post facto laws, there's one against the states as well, but it's a fairly limited list. Okay, that's where matters stood until the end of the Civil War. Right? So the end of the Civil War, Lincoln, during the course of the war, issues the Emancipation Proclamation, but it doesn't have any sort of legal status outside of the states that are rebelling, and it's not clear that it has any effect after the war is over because it's issued as a war order. It's the equivalent of an executive order, but done during wartime. And so the first order of business is the Reconstruction Congress approves the 13th Amendment, which abolishes slavery. I have there in parentheses that the 13th Amendment is unique in that every other provision of the Constitution is about the government. It's a limit. The rights provisions are limits on the government, right? This is why, if you write a letter to the Ithaca Journal and they reject it, you can't claim that they violated your First Amendment rights because they're not the government. But the 13th Amendment uniquely does apply to private actors. And the government, even to this day, well, I don't know about this year, but has brought actions under the 13th Amendment. Typically not what we think of as sort of conventional slavery, but enslavement in essentially all but name. 3 years later, Congress proposes and the states adopt the 14th Amendment. Yes, question?
Sorry, there's another part of the 13th Amendment.
Yeah, there is, and I'm only giving you section 1 of the 14th Amendment too. I didn't mean that was the whole thing. But you want to read it to us?
No, just the part that says except as punishment for crime whereof the party shall be duly convicted.
Right, so this is why,
Can't hear.
so there's another provision, there's a sort of extra clause in the 13th Amendment that allows penal servitude, involuntary servitude as a punishment for crime. This is why people who are incarcerated can be required to do jobs without being paid anything. That's considered permitted by the 13th Amendment, and so it's sort of an exception. Yeah, is that a question in the back?
Yes, if the 13th Amendment abolishes slavery, but only private contract, does it mean the government?
Mm-hmm. No, in addition to forbidding, it forbids anybody, including the government. What's unique about it is, unlike the other provisions of the Constitution, which only apply to the government, this one applies to the government as well as private actors. So, had there been, right, if there, I actually know less about the history than I should, but I think it's probably the case that there were people who were enslaved by Southern governments in the antebellum period, so this forbids that as well, of course. 14th Amendment has 5 sections. I've only given you one of them, not because the others are unimportant. In fact, they've been, year and a half ago or so, a lot of us learned about Section 3 of the 14th Amendment, which is the provision that, at least on its face, prevents people from holding office of the United States if they've engaged in insurrection or rebellion. But never mind. But this is the one that's relevant to the Bill of Rights, right? So there you have it. The first sentence, right? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and state where they reside. So that's been in the news this year, right? So this provision, the primary reason for adoption of this provision is to overrule Scott against Sanford, which is this infamous decision by the Supreme Court in the 1850s, in which they say that Dred Scott, who had been enslaved but was brought by his enslaver to a free territory and claimed he thereby became free under sort of international law principles, and the Supreme Court says, no, he didn't, and by the way, the Missouri Compromise was never valid. Didn't really matter, it had been superseded by the Kansas-Nebraska Act, but in any event, they say that. Oh, and also African Americans can never be citizens. So the court thinks it's like avoiding a civil war. They probably precipitated it, or at least hastened it. So the first sentence overrules that. That's been in the news this year because, right, on January 20th, President Trump signed, among other things, an executive order purporting to limit birthright citizenship so that it does not apply to people born who are the children of undocumented immigrants, or even to people who are, whose parents are in the country legally, but are not, their parents are not permanent residents. Most constitutional scholars, nearly all constitutional scholars, including me, think that that's just wrong, both as a matter of the original history and under a Supreme Court precedent from the 19th century called United States against Wong Kim Ark. Every court to have considered it on the merits so far has invalidated it. Supreme Court, in a case, I'll give you a question in a second. Supreme Court in June, in a case called Trump against CASA, said that a district court exceeded its authority in enjoining the enforcement nationwide, but didn't say anything about the merits of that case. I strongly suspect that case will come back to the Supreme Court, and it's one of the few areas where I think the Trump administration will lose. Yes?
That we have this process to make amendments that requires a certain number of states to ratify them. How can a president believe or have his lawyers tell him that an executive order would overrule a whole entire amendment?
Yeah, so their theory is not that, I mean, they have lots of fairly extravagant theories. Their theory is not that the president can overrule an amendment. Their theory is that, number one, they think Wong Kim Ark was wrongly decided and the Supreme Court should reconsider it. And number two, they think, at least with respect to undocumented immigrants, Wong Kim Ark doesn't apply. On that second point, their view is, in my view, wrong but not completely crazy. That is to say, Wong Kim Ark's parents were in the country legally. They weren't permanent residents, but that's because the whole immigration system was different in the 19th century. And so the core of the government's argument in defending the executive order is to focus on this language, subject to the jurisdiction thereof. They claim that undocumented immigrants are not subject to the jurisdiction of the United States, but that's plainly false because they are, right? That is to say, they can be subject to, as we know, subject to arrest, subject to all sorts of legal orders. So I think I'm not defending this position. I'm just trying to explain that they're not claiming that an executive order can supersede the Constitution. Yeah.
In the 14th Amendment, Section 2, we noticed that that was where they started to really include the word male.
Mm-hmm.
And
Yeah. So Section 2 of the 14th Amendment is, by the way, it's superseded by the 15th Amendment. But what it did was it said that if the southern states, or any state, but they have in mind the southern states, disenfranchise any of the male inhabitants aged 21 or older, they have to pay a penalty in terms of their representation in Congress. But it's the first time that anywhere in the Constitution there's any reference to sex or gender. And in fact, as I'm sure many of you are aware, there was a lot of overlap between the abolitionist movement and the 19th century women's rights movement, right? You go to Seneca Falls, you see that, there are people in both movements who are, signing the Declaration of Sentiments. 19th century feminists are very annoyed by this, to say the least, right? That they, yeah, right. Well, it is a dead letter now because it's superseded by the 15th Amendment just 2 years later. But it does show how they're thinking about these things. And so the gripe is, hey, we were supporting the abolitionist movement. How can you turn around and do this to us? And there really was no good reason to do it. But when the 15th Amendment, which I'll just plop up on the board next, right, is adopted a couple of years later and just says flat out, you can't deny anybody suffrage based on their race, right? The feminists begin what will turn out to be, right, a 50-year struggle for what becomes the 19th Amendment. It's originally proposed as the 16th Amendment. So that's where we are. Yes, sir.
Prior to the adoption of the 14th Amendment, what was the legal status? How did how is this in play? If a person was born here, was it disputable whether or not they were a citizen?
Yeah, so it was almost entirely statutory. There are because well, it's a combination of statutory and depended on your state citizenship. So here's a fun fact. A lot of people mistakenly think that the natural-born citizenship clause, right, which says that only natural-born citizens are eligible to be president, was adopted to prevent Alexander Hamilton from becoming president. That's a common misconception. It's not true. It's true that Hamilton was born in the West Indies, but as the natural-born citizenship clause reads, you had to be either a natural-born citizen or a citizen of the United States at the time of the adoption of the Constitution. And the reason Hamilton was a U.S. citizen at the time of the adoption is because he's a New York State citizen. So the federal definition, other than a few federal statutes, the federal definition is pretty much parasitic on the state definitions. But the reason they put that first clause in there is because, of course, in the states of the former Confederacy, the state definition is not going to be racially inclusive. Yes?
Can you talk some more about that?
Sure. Article 1, Section 8 gives Congress the power over naturalization, right? That's the way in which somebody born in another country becomes a citizen. And so the first part of that, I think, is kind of redundant, right? Of course, if you're a naturalized citizen, you're a citizen. That's what it means to be a citizen, right? So it's not the most felicitous turn of phrase. The importance of it there is it means that they also have to be treated as citizens of the state in which they reside, right? Because you have a kind of dual citizenship. You're a citizen of the United States, but you're also a state citizen, and that gives you certain rights as a citizen of the state in which you reside. Yes?
So before this, there wasn't birthright citizenship. Did every person at some age have to apply for citizenship?
No, there was, in fact, birthright citizenship because that was effectively the rule in the states, at least, you know, for the right racial groups. Okay, we're going to now come to how this relates to the Bill of Rights. Okay, and that's what I have up here as incorporation, which, of course, can refer to the process by which you turn your business into a corporation. So if you get sued, you don't have to give up all your assets. But that's not what I mean by that. Here, there's this process by which the holding of Barron against Mayor and City of Baltimore, remember that's the case that says that the Bill of Rights only applies to the federal government, gets basically wiped away. And what happens is, first, in the slaughterhouse cases, the Supreme Court reads the Privileges or Immunities Clause very narrowly. Let's go back a slide here, right? So look at this language. Okay. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, a normal person reading that language could be excused for thinking, oh, what are the privileges or immunities of citizens of the United States? Well, those are the rights that we have as U.S. citizens. Where do we find those? In the Bill of Rights, right? And so you might naturally think that the meaning of that clause is, so now the provisions of the Bill of Rights also guarantee rights against state governments. That would be a natural reading. Unfortunately, in this 1873 case, the Supreme Court puts the kibosh on that. They say, excuse me, they say privileges or immunities of citizens of the United States, those are uniquely federal rights. And they give the example of the right to travel to Washington, D.C. And say it doesn't have to do with the provisions of the Bill of Rights. This is why, when I teach constitutional law to my law students, I tell them as a freebie, when you're taking the bar exam, whatever the question is, the Privileges or Immunities Clause of the 14th Amendment is the wrong answer, because it's been read to not do anything. So that's read out of the Constitution, even though there's pretty good evidence that that's a mistaken reading. Luckily, however, over the course of the 20th century, especially in the 1960s, the Supreme Court reads the 14th Amendment's due process clause to make most of the provisions of the Bill of Rights applicable to the states anyway. Now that makes perfect sense, I think, with respect to a lot of the rights in the Bill of Rights, especially those criminal procedure rights, right? Right to trial by jury, right to counsel, right to be confronted by the witnesses against you. Those are all things that we would conventionally call elements of due process. It's the kind of fair procedure we would demand before the government can take away somebody's liberty. But the Supreme Court also says that the 14th Amendment due process clause makes substantive rights applicable against the state. So for example, it's because of the 14th Amendment that you have a right of free speech under the US Constitution as against the state of New York. Now you also have that right under the New York Constitution, so you have a kind of double protection. But if New York were tomorrow to abolish its right to free speech as a matter of state constitutional law, you would still have a right to free speech in New York State because the due process clause, by protecting your liberty, is thought to incorporate the substantive provisions of the Constitution. Now, it's a bit hard to get your head around it. The technical term for this is substantive due process, which sounds a bit like an oxymoron, but that's the basic idea. It's linguistically awkward. The reason the Supreme Court got there was essentially they wanted to do it under the Privileges or Immunities Clause, which makes much more sense, but they were too embarrassed to say that they were wrong in the slaughterhouse cases, and so they don't do that. I mean, that's more or less right. Okay. Now, amazingly, the process of incorporation doesn't end in the 1960s. Here are three relatively recent cases, right? So you don't get incorporation of the right to bear arms until 2010. That's partly because the Supreme Court doesn't recognize the right to bear arms as an individual right, as opposed to something connected to militia service, until 2008. In 2019, the Supreme Court for the first time says the excessive fines clause is incorporated. It had long ago recognized the cruel and unusual punishments clause, but that's only half of the Eighth Amendment. In this 2019 case, they say the excessive fines clause. And then in 2020, in a case called Ramos against Louisiana, they say for the first time that in a criminal case, you have a right to a unanimous jury as a matter of federal constitutional law, the incorporation of the Sixth Amendment. As you may or may not be aware, Oregon and Louisiana, until very recently, allowed non-unanimous guilty verdicts in criminal cases. And so that in that 2020 case, the court overrode that. Yeah?
Well, okay, so the other states would have unanimous.
Right.
But if you were being tried in a federal court, does that mean that it didn't have to be unanimous until 2020?
No, this is a good question. So I'm trying to decide whether to tell you about the Apodaca case. Yeah, what the heck. Okay. So when the Supreme Court incorporates a right against the states, it incorporates it what is sometimes called jot for jot, meaning the Sixth Amendment right to counsel means the same thing in federal court as it does in state court. Same thing for the takings clause. It makes it easy. You don't have to like have one list for the feds, one for the states. But there was this one weird case, Apodaca against Louisiana, in which the Supreme Court fractured. Some of the justices, this is in the 1960s, some of the justices said the Constitution doesn't require unanimous juries even in federal court. That was a minority position, but there were 3 justices who said that. A different 3 justices said the Sixth Amendment right to a jury is not incorporated at all. You put those 2 together, and they upheld the Louisiana non-unanimous jury. That stayed on the books. I might have had some of the details wrong, but that's the basics of it. That stays on the books until 2020, when they get this Ramos case, and they say, that makes no sense at all. We're just going to consider this over again. And because we have jot for jot incorporation, we're going to say, no, you get a unanimous jury even in state court. Okay, now, you might be wondering, does the 14th Amendment incorporate every provision of the Bill of Rights? The answer is no. Can you tell me which ones it doesn't incorporate?
The Eighth Amendment.
Eighth Amendment is incorporated.
It is?
Yes.
You know they have different death penalties. Sorry, what's the question?
The question is, which provisions of the Bill of Rights do not apply to the states, that is, they are not incorporated? So the reason why some states have death penalties and others don't is because the Eighth Amendment has been construed to allow the death penalty, but it doesn't require any state to have the death penalty. All right, I'll tell you.
Yeah.
There are only three. Yes?
What one? Searches.
It is the Seventh Amendment. Seventh Amendment is one of them. So this is, now, in New York State, we have civil juries, but not for everything. Under the federal Constitution, you get a right to a civil jury, meaning a jury in a civil case, so long as the amount in controversy exceeds $20. It's a pretty low number. Now, you might think there should be a cost of living adjustment, but no, it's $20. Yeah, right. That would be small claims court in virtually every state. So but you have to have a federal claim too. So it's hard to have a federal claim worth about $20. It's also hard to find a lawyer who's going to take your case for $20. Okay, but here are the ones that are not incorporated. The Third Amendment. Now, the Third Amendment isn't incorporated because they've never had a case involving that. Maybe we will if if some of these National Guard troops need a place to stay. The right to a grand jury indictment has not been incorporated. So some states indict. New York, again, has a grand jury requirement, but some states don't. They indict by what's called an information, and then the civil jury provision. Yes?
That was my question at the beginning. Why was a quartering of soldiers part of the Bill of Rights?
So the question is, why was the prohibition on quartering of soldiers part of the Bill of Rights? I'm going to treat that as a broader question. We can ask, why is anything part of the Bill of Rights? And I think it's fair to say, to go back to a question we had earlier about the First Amendment, that there is a combination of things going on. In some sense, what they're doing is they're putting down rights that, as Jefferson says, they think one should have against any civil government as part of a sort of democratic society. So the First Amendment is mostly stuff like that. But in other ways, they're putting down rights that are some combination of traditional British rights, right, under the British Bill of Rights, and they're traditional stuff, and they're putting down responses to what they thought of as special abuses by the king during the Revolutionary period. And quartering of soldiers was one of those, that was considered to be an abuse by the king during the Revolution. Yes?
And that is right in the Declaration of Independence. That is one of the complaints they have against the king.
There you go.
Yeah, so it was cool.
Yes?
Isn't vicinage not incorporated as well? Not on there.
The vicinage requirement. Yeah, but that's because it doesn't apply. Right? It's not clear what a vicinage would be within a state. Yeah, maybe. Okay. Yes? Go ahead. You're wondering what vicinage is? Right, so that's that when you have a right to a jury trial, but also you have the right to be tried in the place where the crime is committed, the vicinage, yeah.
So in the quartering of soldiers, they're not allowed to quarter during times of peace.
Right.
Well, our current president says we're at war with ourselves.
Right, so that would be a question of what counts as peace and who gets to decide what counts as peace. Yeah. Yeah. Are we ready to move on? Okay. Now, there are some additional rights that we get after Reconstruction and after the most of these arise before the full incorporation, but there are other provisions of the Constitution, right? Some of which have to do with rights. All of the provisions of the Constitution adopted after the 15th Amendment are either voting rights provisions or structural provisions like the direct election of senators, or sort of housekeeping measures like the changing of the date of presidential inauguration and things like that. But the ones that are individual rights all concern voting, right? So the 19th Amendment forbids sex discrimination with respect to voting. The 23rd Amendment gives residents of the District of Columbia a right to vote in presidential elections. They still don't have representatives in Congress. That's why the DC license plates say taxation without representation. Well, they don't. She doesn't have a vote. Right? Yeah, yeah. 24th Amendment forbids poll taxes in federal elections. There was a Supreme Court case that forbade them in state elections as well, so that's effectively forbidden in both. And the 26th Amendment, right, adopted during the height of the Vietnam War, means that 18-year-olds can get to vote. It actually forbids discrimination against people under that age with respect to voting, but it effectively extends the franchise to 18-year-olds. So those are the additional ones. Now, this talk was billed as talking about the amendment process more generally, and so now I want to talk about the 27th and possibly 28th amendments. Okay, so here's the amendment process, right? This is Article 5, and it sets out actually a number of possibilities, but only one has ever been used, and that one is that a measure passes by a 2/3 majority in each House of Congress and then is sent out to the states to be ratified by 3/4 of the state legislatures. You could also have a national constitutional convention. You could also have state ratifying conventions. These have been proposed from time to time, but never approved. The process has always gone this way. So that's the process. I should say that in contemporary times, right, if you compare the US Constitution with other constitutions around the world, or just with state constitutions, the US probably has the most difficult to amend constitution there is, which is almost certainly not what was intended by the framers, right? And it turns out not to be, right? So in the just 2 years after the adoption of the Constitution, you get 10 amendments. You get another 2 within the next decade, the 11th Amendment, which provides for sovereign immunity for states, and the 12th Amendment, which addresses the problem that the president and the vice president are now running as a ticket, right, which led to the deadlock of the election of 1800. Then you don't get any more until the Civil War. And then you get these dribs and drabs. And the reason they come in dribs and drabs is because it's so difficult to amend. And so that's just a feature of the system. And there are some people who argue that because it's so difficult to amend, that explains why the interpretation of the Constitution has changed so much over time, because the pressure that in other legal systems might find a release through the amendment process ends up being channeled into the Supreme Court through the interpretation process. Okay. So the 27th Amendment, remember when I said an hour ago that Congress originally proposed 12 amendments? Well, the second one of those read like this. No law bearing the compensation for the service of the senators shall take effect until, okay. So what that means is, if Congress votes itself a pay raise, it doesn't take effect until an intervening federal election, right? The idea was they were worried that Congress would be just, giving itself too much money, and so they'd have to face the voters before they get their money. This is defeated by in the original process, but then, so that's what happens there. In 1982, this undergraduate, Gregory Watson at the University of Texas, writes this paper for a political science class he's taking saying, hey, it didn't contain a time limit, so maybe I could take it around and get it ratified. He gets a C from his professor. To exact his revenge, he then goes around from state to state, and he gets 38 states to ratify it. In 1991, I believe, this becomes the 27th Amendment. Now, there's a question. You should, for the guys for fortitude. Yeah, right. Yes.
Yes, it does. Yes, it does.
So, right? You might say, well, is it valid or isn't it? Congress, I guess, reading the writing on the wall, says, hey, we're going to abide by this. They pass a resolution declaring it valid. And then the archivist says, okay, it's valid. And so if you read your copy of the Constitution, it's got a 27th Amendment. But now you say, well, what about the Equal Rights Amendment? So, Equal Rights Amendment, first introduced in 1923, reintroduced periodically, until finally it's passed by Congress, by 2/3 of each House of Congress in 1972. House first, then the Senate in 72. There it is, right? It has this little preamble in the bill that Congress passes, right? The following article is proposed as an amendment to the Constitution, which shall be valid, right, when ratified by the legislature of the 3/4 of the states within 7 years from the date of its submission by the Congress. So they include a time limit. Now, interestingly, they did this before they knew about Mr. Watson's gimmick. I'm not sure why they included this time limit, but they do. But that's not part of what goes to the states for ratification. What goes to the states for ratification is just this, right? Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And then they have a couple of, how it goes in. And then it says it takes effect 2 years after the date of ratification. Well, that's fine. So initially, it looks like the ERA is going gangbusters. Then Phyllis Schlafly discovers it, and it gets derailed. So Congress, by a simple majority, not clear where they think they get the authority to do this, but by a simple majority, extends the deadline to 1982. 1982 comes around, doesn't happen. But now we ask, well, so what? Because Virginia, just a few years ago, became the 38th state to ratify. Let me go back, right? So that's, and so the question is the ERA now the 28th Amendment? Well, to answer that question, we have to answer a bunch of other questions. The first question is, was the initial time limit of 7 years valid? Well, in a case called Dillon against Gloss, decided in 1921, the Supreme Court said a time limit in an amendment is valid. But the time limit in that amendment was part of what Congress sent out to the states. It wasn't just part of the resolution. So arguably that's different, that Congress can include a time limit in the proposed amendment text, but maybe not in, maybe if they put it in in the resolution, that doesn't count. So if that's the case, then the time limit doesn't matter. So if that's true, then ratifications are still open, and then it doesn't matter whether Congress had the power to extend the deadline to 1982 when they did, because they didn't need to extend it at all. Okay, so that's the argument in favor of its validity. Right? Distinguish Dillon against Gloss is saying it matters whether the time limit is part of the amendment itself. But, right, as I said, 2020, Virginia became the 38th state to ratify. But meanwhile, 5 states rescinded their ratifications. Did they have the authority to do that? No. Well, I know we want to say no, but I think it should be clear that after the 3/4 of the states ratify, a state can't then unratify, right? So once, I don't know, Mississippi couldn't today unratify the 13th Amendment, right? They're actually one of the later states to ratify, like I think in the 21st century. But because once it becomes part of the Constitution, then the time's up. But it's not clear whether you can unratify before the total has gotten to 38. Is it a one-way ratchet? We don't know the answer to that question. Guess what else we also don't know the answer to? Who decides all of this? This year, a few days before leaving office, President Biden, under unremitting pressure from Senator Gillibrand, says, okay, I'm declaring that it was validly ratified. What authority does the president have to do that? President is, unlike Congress, has no role in the proposal of amendments. The archivist has refused to certify. Now, you say, well, who the heck is the archivist? The archivist is an appointed librarian. No shade to librarians, right here, I wouldn't say that, but it's kind of a bonkers legal system that would say that whether a provision is part or not part of the Constitution is to be decided by a single librarian, right? Here's the text. Whenever official knows the national, the archivist shall forthwith cause the amendment to be published. Well, published doesn't mean that the archivist is making the substantive decision. But if not the archivist, then who? I think the answer to that question is probably Congress. But again, that's kind of weird, right? Congress by what mechanism? So remember when I was introduced, you heard that stuff about how wonderful the US Constitution is? Like, it's got a lot of gaps. This is one of them, right? It ought to specify who gets to decide. Now, here's how this would be decided in almost any other constitutional democracy. The Supreme Court would decide, right? The Constitutional Court would hear that. Well, yeah. But even apart from the current personnel of the Supreme Court, in the US, our Supreme Court has said years ago that whether an amendment is validly adopted is not something for courts to decide. It's to be decided by Congress. So Congress could, I think, probably by a simple majority, as they did with the 27th Amendment, pass a resolution declaring that the 28th Amendment has been validly ratified, because I think the questions about the time, I think you can go either way on that. So I think Congress could decide those matters, and then, at least as I read it, the archivist would be obligated to publish it. Now, I don't think that's going to happen with the current Congress, but you know, you can always hope that someday there'll be elections and a different Congress. Question?
And don't you think that would make the original writers of the Bill of Rights happy? Because the way it's designed, Congress is supposed to be the most powerful of the three branches, right? But the power rests with
The people. Right. So you, and you
the
can
lead of the people, but the people, yeah.
Yeah, but you can look to
Right.
Sure. I mean, you know, there are lots of features of the Constitution that have that assumption baked in. So the fact that Congress has the power to declare war is based on the assumption that Congress will be closer to the people. If you're going to make the awesome decision to take the country to war, you should have buy-in from the people. The fact that bills for raising revenue have to originate in the House of Representatives, which having more members is closer to the people, right? So that's, you know, that sort of underscores the sort of democratic assumptions of the Constitution. Yeah.
Congress has the power to decide it's been ratified. Do they similarly have the power to say, hey, it hasn't been ratified?
Well, I assume so. I mean, yes, presumably, well, not presumably. You could have a regime that says, well, the courts are going to defer to Congress if it's at least a close question. They tend not to phrase it that way, but, you know, at least here it is, I think, a close question where you can dispute whether it's satisfied or not, because there are a bunch of these questions that can come out either way. If it were up to me, I would say, you know, that the court should defer to Congress in a close case. I don't think that's how they're going to do it, though. But so yes. Yeah.
Congress has created some laws somewhere along the way saying that there's, protections against discrimination on the basis of, a number of factors. and one of them being sex.
Mhm.
And how does that law apply to, say, any of this in states? And why isn't that superseding? Why do we need an amendment? Why does the federal or Congressly passed prevention of discrimination not hold in states?
Right. So there's Title VII of the 1964 Civil Rights Act. There's Title IX, which is added later. Interestingly, Title II does not forbid sex discrimination. That's why that's the provision governing public accommodations. That's why bars can have so-called ladies' nights. That usually gets a laugh. I mean, it's true, but it usually gets a laugh. It's weird that the public accommodations law doesn't apply to sex, although state and local law, public accommodations laws do. But so those laws, for the most part, apply to private businesses, right? So remember when I said the Constitution, except for the 13th Amendment, only applies to government actors? So if you think about the civil rights movement, right, the lunch counter protests and so forth, right, they're going to private businesses which were not violating the Constitution when they were discriminating on the basis of race. That's what precipitates the 1964 Civil Rights Act. So it's primarily about extending civil rights as against private actors and not necessarily as against the states. Now, having said that, a lot of these provisions also do apply against the states, and where there are such provisions, they can be enforceable. And so a lot of things, so for example, if a state employer discriminates on somebody on the basis of sex, they're going to be liable in the same way that a private employer would be, subject to an exception under something called sovereign immunity that I could explain to you, but it would take me about 6 hours. But I want to answer your question by pointing to the next part of this slide, if I can. Yeah.
Women go and have health care. HIPAA says health care is private. Women's health care is not private. Somebody in the government says if she's coming in for an abortion, you have to tell somebody else she's coming in for an abortion. It's no longer private. She's now being discriminated against in a private setting. How can that be?
Well, so the prohibitions on discrimination are all domain specific. So there's a prohibition on sex discrimination with respect to employment and with respect to federally funded entities, which might or might not include hospitals depending on the particular setting. So it could be that, but there is not a kind of general prohibition on sex or other kinds of discrimination. They're in particular settings.
It's a particular setting.
Right.
Hospitals almost all have Medicare reimbursement.
Right. Yeah. So some of that is illegal. I mean, yeah. I agree.
Because HIPAA prevents that from happening.
Well, HIPAA is more about privacy.
ACA says you can't discriminate on the basis of sex.
Correct.
So all of those payments are federal to those.
Yeah, I agree. Those are good. So some of what's happening there is just flatly illegal. Sure. Yeah.
Privacy, can you say a word about what it's been doing? And the other thing is, are there other implied rights on the way?
Yeah, sure. So can I just hold off on that for just a minute? Because I want to just finish this up, and then we'll talk about that. Okay, so I just wanted to finish up. So during his first term, President Trump instructed his Attorney General to instruct the archivist not to certify the 28th Amendment. I think he had no more authority to do that than President Biden had to declare it part of the Constitution. And so the conclusion to whether the ERA is the 28th Amendment is maybe. So that's sort of where we were already. Okay, now you might ask, does it matter whether the 28th Amendment is part of the Constitution? And the answer to that is, yeah, probably a little. So Craig against Bourne is one of my favorite cases. So this is a case arising out of Oklahoma. Oklahoma at the time had a law that said in order to purchase alcohol, you had to be 21. But if you were 18 and female, you could purchase beer containing no more than 3.2% alcohol. This was challenged as discrimination against young men, and they won. And the Supreme Court said, come on, you can't do that. But in the process, right, this is 1976. It's before the ERA has been fully defeated, right? In the process, the court says that under the 14th Amendment, right, no state shall deny any person the equal protection of the laws. The Equal Protection Clause, laws that discriminate on the basis of sex are subject to something called intermediate scrutiny, meaning that unlike most laws where, you know, the court's going to defer to the legislature, if a law discriminates on the basis of sex, the government needs to advance an important government interest and show that the law is substantially related to that. Now, this is a stricter standard than is applied to most legislation, but it's not the strictest standard, which appropriately enough is called strict scrutiny, which applies to laws that discriminate on the basis of race, national origin, and a few other categories. So one impact of treating the ERA as valid might be, it would depend on how the courts construe it, but because the amendment itself doesn't say anything about it, it might be to ratchet up the level of scrutiny that applies to laws that discriminate on the basis of sex to strict scrutiny from intermediate scrutiny. And that could make a difference in a whole category of cases, but not in the case you're thinking about. So I write here, it would be naive to think that ERA ratification would lead the Supreme Court to recognize a right to abortion again. And the reason for that is that in Dobbs against Jackson Women's Health Organization, right, the case that overruled Roe v. Wade, Justice Alito, writing for a majority of the court, says laws that ban abortion are not sex discrimination at all, right? Relying on an earlier case called Geduldig against Aiello, in which the Supreme Court said that discrimination on the basis of pregnancy is not sex discrimination, because such laws don't discriminate between men and women. They discriminate between pregnant and non-pregnant persons. I don't make this stuff up, I just report it. And Justice Alito relies on that in the Dobbs case. So even if you had strict scrutiny for sex discrimination under the 28th Amendment, I'm pretty sure that this court would say, well, that doesn't matter because this isn't sex discrimination at all. Laws forbidding abortion aren't sex discrimination. Now, that's a little bit different from, now you may remember in the last statewide election, New York adopted an equal rights amendment, which under the sort of legislative history is understood to codify in the state constitution a right to abortion. It's got a different history, it's got a different bunch of people interpreting it. So I just think it's just a mistake to think that ERA ratification would have very large effects other than potentially in some category of edge cases that are now subject to intermediate scrutiny, but might in the future be subject to stricter scrutiny. Yeah.
The whole process over all these 200 years of deciding cases and talking about precedents and somebody here relying on whatever, but on the other hand, throwing out precedents when they don't like it? I mean, how is that all integrated?
Yeah, so, yeah, you're asking me, have I wasted my life? I like to think that the Constitution maybe is the friends we made along the way. I don't know. I mean, right, it's maddening. Yes, I agree. I guess let me say this. The Supreme Court has always been political, right? It has always been willing to overturn precedents that it didn't really like. I think what has changed is the degree to which the current politics of the court so completely align with partisan party politics, which wasn't always true, right? So the Warren Court, which was seen as very liberal, the two leading figures on the Warren Court were Earl Warren, Republican governor of California, and William Brennan, who was also appointed by Eisenhower, and they were the ones sort of leading this sort of liberal court. But basically since the retirement of Justices Stevens and Souter, who were both Republican appointees, it's been true that every Republican appointee has been more conservative than every Democratic appointee. So, and a lot of the decisions have seemed to be, breaking down on party lines, not just on ideological lines that sort of have some connection to party politics. And so I think that's, quite disturbing. Okay, now I think I'm done. Let me just, I think the next slide will say like questions, discussion, or whatever. Yes, there we are. I wanted to take that question first. So you asked about right of privacy, unenumerated rights more generally. Okay, so remember that I told you about substantive due process? So substantive due process is the way in which the court gets substantive rights incorporated against the states. That's why you have a right to free speech, free exercise of religion, under the US Constitution that applies against state governments. But it's also the mechanism by which the court has found so-called unenumerated rights, like the right to contraception, the right to marriage, the right to abortion when you had such a right, and some others. And my own view for what it's worth is you don't really, like linguistically, that's not the most natural way to get there. The most natural way to get there is via the 9th Amendment, right? That's the provision that protects us against this, the worry that, Jefferson has and Hamilton has, right? There are unenumerated rights out there, and the Privileges or Immunities Clause as against the state. So it's the 9th Amendment directly for the federal government, Privileges or Immunities Clause incorporating the 9th Amendment against the states. I think that is a perfectly good, actually most natural textual reading of the Constitution. The only problem is then you say, well, what are the unenumerated rights? Okay, we know they're out there, but what are they? And the sort of most eloquent exegesis of this comes from Justice John Marshall Harlan. There were two justices, John Marshall Harlan. There was the first one who dissents in, he famously dissents in Plessy against Ferguson. And then there's his grandson, who serves in the 1950s and 60s. And so Harlan, in a lead up to the contraception case, says that the Bill of Rights is not a series of isolated pinpricks. It's a rational continuum. And the way you figure out what the unenumerated rights are is you sort of interpolate and extrapolate from what's there. And that's and it says, and it's going to contain, protect you against sort of arbitrary government. And then he has a bunch of things that he says about that. I don't agree with all of his illustrations. He was a product of his time, so he puts them along his list of things that the government can obviously forbid. He includes homosexuality. But he's writing in the 1960s. He's a sort of, not to say that that view wasn't controverted in the 1960s. It is to say that he was a product of sort of conventional thinking at the time. But his methodology is sort of broader interpretive. The court in recent years, especially in Dobbs, has backed away from that and has emphasized a different proposition, and to say that, well, the unenumerated rights that are protected are those that are, quote, deeply rooted in our history and tradition. And to my mind, that kind of undercuts the point of a Bill of Rights, certainly one that recognizes unenumerated rights, because it's just going to sort of perpetuate whatever traditions you have of subordination, which are by definition going to be challenged. But that's sort of where I think I see this going. Yes, in the back. Yeah.
Well, what's the role of the preamble of the Constitution for helping to figure out those innumerable rights? Because one of the 6 reasons why we have a federal government and we constituted this republic was so that we have the be half dead before. That's how it's being interpreted in all these states now that are in fact dying. And when you talk about the words of life, liberty, and privacy, why would anybody ever interpret that something that would cause the death of the individual, but individual does not have any decision capacity about?
Yeah, so we'll take the first part of the question first. And so what is the role of the preamble? So traditionally, very little. You occasionally see references to it. There was a very famous constitutional scholar he taught at Yale Law School, but before that he sort of cut his teeth working with Thurgood Marshall on the briefs in Brown against Board of Education, named Charles Black. And he wrote a very nice little book talking about the relation of the preamble and the Declaration of Independence to the Constitution, explaining how they could be used to inform the Constitution, and giving some examples of how it sort of had been done. I think it's a beautiful book. I knew Black a little bit because in his later years he was an emeritus professor at Columbia, where I taught for 13 years. But his view was never really accepted. On the abortion question, I mean, I agree with you as a matter of policy and as a matter of how I would interpret the Constitution. I mean, what what Justice Kavanaugh says, concurring in Dobbs, is, well, these are hard questions because there's the interests of fetuses on the other side, and we're not deciding in favor of one side or the other. We're just leaving it to the elected representatives. I'm not endorsing that. I'm just telling you that's what they say. So. No, they would say that well, of course, if you can, so I think what they would say is the states get to regulate medicine, and there might be particular cases where someone could show this, that, or the other thing, and then they could have the claim. Again, you're asking me to defend a position that I don't hold, so.
They upheld it then in Idaho, Tala case, where women coming in with actual life threats.
Right. Well, that I think was just a misinterpretation of the statute.
I mean, I don't believe that they're actually being given the medical information that they need to actually make appropriate decisions.
But they don't care.
Right. No, they don't.
Yeah, you had a question.
I wanted to ask about the Second Amendment. Because you referred to the legal case that switched the meaning.
Right. Just to call me again.
I understand it really well, not a legal scholar, not a lawyer or anything, but I just want to understand the comma.
Yeah.
There's a big deal made about
Right.
a comma. Because I thought that
a well-regulated militia being necessary to the security of a free state,
I thought
comma,
that would be
the right to keep and bear arms shall not be infringed.
Yeah.
Right.
is
So.
what state national.
Right.
So
So.
I thought that.
Right.
Go ahead.
Okay, so in 2008, in District of Columbia against Heller, the Supreme Court hears a challenge to the District of Columbia's law, which restricts handgun possession. And for the first time, the court, an opinion by Justice Scalia, says, well, we construe the language of this to protect. He says that the right to keep means to keep, to possess, and to bear means to carry. It's right to bear arms. And he says that in its time, the idea was that the militia didn't refer to the so-called organized militia, but referred to the sort of the body of the people. And there's some linguistic evidence for that. And so the idea was people would have their weapons and for personal use, and then they would be called upon, by Paul Revere riding through the British are coming, and they would show up for militia service, but they could have their weapons otherwise. Now he then has to face the question, well, but why do they put in the stuff about the militia if it's just about having your weapons? And he says, the reason they codified the right was because they were concerned about a militia, but that, what he calls prefatory clause, doesn't restrict the operative clause. It just provides a reason. Okay, again, I'm going to now give you an analogy, which I don't accept, but I'm going to give it to you just so you understand what they're saying. Right? So suppose that the First Amendment had a prefatory clause that said something like a red people being necessary to the health of a democracy, the right to freedom of speech shall not be infringed. Okay. And then we have a question whether music, music without lyrics, is protected by the First Amendment, right? I think we would want to say, or I would want to say, parallel to Scalia's argument, notwithstanding the fact that the core purpose of the First Amendment is about the health of the democracy, music without lyrics is also encompassed within freedom of speech. That's I think, the nature of Scalia's argument there. I don't think it's a very good one in light of the actual history that I think he gets wrong, but that's what he's trying to do with the prefatory clause. He's saying it states a reason, but it doesn't limit the substance of what he calls the operative clause.
So do you think the court is shy to further abridge the right of the people to bear arms by restricting the people's right to weapons to certain types? Like, because then we get into the whole thing about military-style weapons.
Yeah. So a couple
So
things.
some are for the military, some weapons are for the military. Clearly, if I start like building a nuclear weapon in my backyard, the feds are gonna come after me.
I should hope.
Not unless I'm really smart, which I'm not. But that's not the case when it comes to certain kind of weaponry, which was and is was created and primarily used and for military use.
Yeah. So the argument is kind of weird, right? The argument for the individual right to bear arms, because what it says is, well, the reason that it's connected to the militia is you would bring the weapons you have when you're called upon to do militia service. But that suggests that you would especially want to bring your military weapons, right? So if you have a, rocket-propelled grenade launcher, right, that you keep at home in case, you need it for hunting or something, and then you're called upon to do militia service, and you're going to, right? And Scalia sort of recognizes that. He then comes up with this definition. He says, well, what the Second Amendment protects is those weapons that are in common use by law-abiding people for lawful purposes. Now, lawful purposes is circular. Basically he's trying to say, like, the kinds of weapons people commonly have. Dissenting in that very case, Justice Breyer says, well, that's stupid. If somebody, he doesn't say that, but he says, suppose somebody invents some new weapon that's really deadly. If the states and Congress completely ban it, then it'll never be in common use, and so no one will have a right to keep and bear it. But if the states and the government, federal government, take a while, then all of a sudden it's protected. This is a live issue with respect to semi-automatic rifles, because there's something like 1 million of them at large in the country. 3 million, whatever it is. I knew the number at one point.
The AR platform is the most popular rifle in the country.
Okay, so are they in common use? Yeah, I think so. But are they suitable for home protection? Well, you might think, no, they're suitable. I mean, especially given how easily they can be modified to be made fully automatic weapons. Now, there is the court has not invalidated the machine gun ban, but
Although pump stocks are bad.
right, yeah. So there you have it.
Okay, thank you.
Sure, yeah.
I'm actually in sense of that now.
Okay.
Yeah, a different question. So Trump is regularly saying he's going to take away somebody's citizenship, whether they're birthright or whether they're naturalized. What's the impact of that? I mean, if he tells his Justice Department, do they have any constitutional?
No, I mean, so a naturalized citizen can lose their citizenship if they committed fraud or something else in their application, but they're entitled to full due process in that. And you can't take away people's birthright citizenship. There's just no procedure for doing that. So it's like a lot of things he says. Yeah.
strong constitutional arguments that would warrant the executive office or members of Congress to label speech that they disagree with, right, in some category that has valid restrictions, like shouting fire in a theater. Is there anything that makes it difficult for them to pull that off?
Yeah, sure. So the First Amendment, as a protection for freedom of speech, has been construed to allow the government to regulate speech in one of two ways. So first, there's a small number of categories of speech that are considered not really protected at all. So the leading one is incitement to imminent violence. Yes, I understood what that was about. That's a pretty strict definition. Another one is sometimes called fighting words, which has not really been used much by the courts in recent years. Sometimes you see defamation as listed, but defamation isn't wholly unprotected because there's the fact that you can't have defamation for true speech, and if the speech is about a public figure or a public official, you can't have liability without proving so-called actual malice. So there are limits on that. In a case called United States against Stevens in 2010, the Supreme Court said that there aren't any new unprotected categories. So the ones I mentioned, there's also obscenity, child pornography, and I'm probably leaving out one or two, but true threats, another example. True threats. Yeah, right. So you can't threaten that you're going to kill somebody. I mean, if you're joking, then it's not a true threat. There was a case just a couple of years ago called Counterman against Colorado about whether you evaluate whether a threat is a true threat from the perspective of the threatener or the threatenee. And the court said I kind of hedged, said a little bit of both. Well, so you can be so there can be liability for making a threat even if the person threatening it doesn't intend to or is incapable of carrying it out, as long as the person threatened doesn't know that or doesn't have reason to know that, because the idea is that the threat is itself very harmful. But the government can't, by fiat, just label something as falling into one of these categories, nor can it create new categories. The closest I think the court has come to allowing something like that was a case during the Obama administration called Holder against Humanitarian Law Project, in which the court said that a law forbidding giving material support to terrorism, as applied to people who were just counseling people in the Middle East about how to engage in nonviolent protest, because the people they were counseling had previously been engaged in violent activity, that the people doing the counseling were subject to this law. Now, the court said that was an infringement of their freedom of speech, but the court went on to say that it's justified, I think incorrectly they said this, but it's justified because material support to terrorism is permissible. And that's material support for terrorism is permissibly prescribable. That's the second way in which the government can limit speech, is it can even an area of protected speech if the government can satisfy our old friend strict scrutiny. Remember strict and intermediate scrutiny? Then they can forbid certain kinds of very harmful speech. So that's your sort of fire in a crowded theater or what have you. Yeah.
If I understand what is happening correctly, people are being arrested in the UK now for demonstrating about, in their words, the genocide in Gaza. And they're being arrested on the premise that they are promoting terrorism.
Right.
So that's the kind of thing that seems to be around the corner. So what you're saying is that you feel, even with the current legal situation, that that isn't likely to happen here, or do you think it's kind of a crapshoot?
Well, so for the most part so far, the way in which the Trump administration has unconstitutionally suppressed speech is by withholding of federal funds from recipient institutions like universities, illegally, but doing it and getting away with it for the most part, threatening or bringing frivolous lawsuits, but then effectively coercing settlements because of the fear of pretextual regulatory denials in other contexts, right? That's why CBS settles the 60 Minutes lawsuit, even though it was frivolous. It's why ABC did the same thing with their lawsuit. And just sort of generally threatening all sorts of things that are not criminalization, right? They're not locking Jimmy Kimmel up, but there are these, there are some smart people in the Trump administration who have sort of figured out where the pressure points are and are applying them. And, another example would be the law firms, right? There are ways of fighting back, but often the calculation is that you fight back with lawsuits. By the time you win, first of all, you might not win. Second, by the time you do win, you may, the game may be over anyway. And so that's why you see all of this going on. I guess if you want to look at the glass half full, you could say, well, at least they're not imprisoning Stephen Colbert and Jimmy Kimmel. They're merely making it impossible for them to earn a living. So there's your glass half full for tonight. Yeah.
Well, with regards to the gentleman's point, what about recent news that Trump was going to declare Antifa a terrorist organization?
He did do it. He did it by text.
So,
At 3 o'clock in the morning.
the problem for him, of course, is that Antifa is not an organization. It's just a slogan, right? Okay. But the next thing, of course, will be to say that, the Ford Foundation is Antifa, right? So that's the worry.
Or any of us in the streets.
Right.
Yeah,
I do think that, what's weird about this is that, in a way, it's better to have no power or money. Like, I can say whatever the heck I want on my blog, because they're not reading my blog. My blog reaches, 10,000 people. They're influential people, but it's not having an effect on mass opinion. I'm not, Jimmy Kimmel or Stephen Colbert. Likewise, I'm not getting federal funding directly. Cornell gets federal funding. They employ me, but I'm confident that my, tenure at Cornell is not going to be disrupted by that. But it's kind of like the most dangerous position to be in Russia is to be a Russian oligarch, right? Because the more power and money you have, the more leverage Putin has over you. And so that's why I think the administration has been targeting Harvard and Columbia and Cornell and Northwestern and not smaller little liberal arts colleges, why they're going after big law firms and not individual lawyers, why they go after the major news organizations and not bloggers. Doesn't mean they can't or they won't, but they do seem interested in sort of the forms of law, and so withdrawing funding is kind of a gray area. So there's that. I mentioned my blog. My blog, by the way, is Dorf on Law. That's dorfonlaw.org. You can subscribe. You can get it on Blue Sky. And so one of my co-bloggers is a economist and law professor who has he was at George Washington University, then he was recruited to the University of Florida, then DeSantis became governor and he exiled himself, and he's now living in Dublin because he's had enough. But anyway, he's referred to the Trump administration as engaging in legalistic lawlessness, which I think is a nice term, right? That is, it uses the forms of law to subvert the law. I guess I'd rather have legalistic lawlessness than utter lawlessness. But yeah, or or you know, our utter overthrow of the regime we've got. So that's why I'm thinking of this as the glass half full. Sorry? Yeah, it's true. I mean, a lot of autocrats are initially elected. Yeah, yeah. All right, let me take, so they want us to leave, they told us we're closing in 15 minutes. Let's go for another 5 minutes. Yes. Someone who hasn't spoken much yet. Yeah.
Have you ever heard any suggestions on how to change the structure of the Supreme Court that make any sense?
Yeah, sure. So the leading proposal, which is favored or had been favored by a lot of people across the political spectrum, was to have 18-year term limits, 18-year term limits, and to have every presidential term you get 2 appointments, subject to appointments in case a vacancy arises through death or early retirement. And that would sort of avoid this problem of justices staying on, you know, past their competence, and the problem of presidents appointing very young people, justices sort of trying to time things. There's a question as to whether it's constitutional. There was a book a number of years ago by a Duke law professor named Paul Carrington and Roger Crampton, who was the former dean of Cornell Law School, proposing this, and they argue that it could be done with an ordinary statute. The reason why you might think it can't be is that Article 3 of the Constitution says that judges and justices shall serve during good behavior, which is a term of art, meaning it's like tenure. And so you might think, well, they can't, that means life tenure. And what they say is, no, they serve on the federal courts for life, but after 18 years, you would sort of rotate them off and they could go to a federal appeals court, kind of in the way that justices now, after they retire, can sit by designation on federal appeals courts. So after Justice Souter retired, he heard a lot of cases in Boston as a federal appeals court judge. And in the early days, justices of the Supreme Court actually did double duty. They did something called riding circuit, which meant that in addition to sitting in the US Supreme Court, they would also go out and hear cases in the hinterlands. And so the Crampton-Carrington argument is, yeah, this is consistent with the text of the Constitution. The hard part would be, A, getting Congress, you know, and the president to agree to it. So this was the Biden commission that studied various proposals. I would say that this was the one that they looked most favorably upon, but the ultimate conclusion was, well, we're not sure about this. I think that's the most practical approach that actually would work. Most proposals to do this have a phase-in, right? So it doesn't apply to sitting justices, so it doesn't do us any good, you know, for the next 10 to 15, 20 years, however long it takes, you know, for the Earth to pass 3 degrees centigrade or whatever it is. Yeah. Well, last question.
Are the Bill of Rights supposed to apply to everyone who is physically here in the United States, or only to citizens and what's?
Yeah, so nearly everything in the Constitution refers to persons, not to citizens. The Fourth Amendment says the right of the people. The Supreme Court has said that that means you have to, it doesn't apply to non-citizens outside the country, but it does apply to non-citizens within the United States. One problem, remember I had up the privilege, I said earlier the Privileges or Immunities Clause could do the work that substantive due process does for incorporation. One problem with that is that the Privileges or Immunities Clause, that actually does refer to citizens rather than to persons, but you know, we could find a way around that. The one exception I'll say is, so the court has treated Congress's power and the president's power over immigration as extending the border beyond the border. So this is why they have more power to have like roadblocks in San Diego than they would in the middle of Kansas, because it's sort of closer to the border with Mexico. I'm not sure that I think that makes a whole lot of sense, but that's the way it's been. But in general, people who are here have due process rights, have other Fourth Amendment rights, et cetera. So.
How it came to be that the SCOTUS says that our president can have immunity from illegal acts?
Yeah.
They said it. What they said was, so they relied on.
Tompkins County Public Library will close in 10 minutes. These areas and all study rooms are now closed.
So as David Bowie asked, do you remember your President Nixon? So in a case called Nixon against Fitzgerald, somebody sued President Nixon in a money damages case. And the Supreme Court in that case said that the president has absolute immunity against civil damage lawsuits for his official acts, right? And that's the principal case that the Supreme Court in Trump against the United States relies on. They say, well, if the president has immunity against civil damages, you know, a criminal prosecution could be even worse. So he's got immunity against criminal prosecution. Now, I don't think it makes any sense, especially because, right, the impeachment clause specifically says that, well, impeachment, you know, after, although someone is impeached and removed, that doesn't subject them to criminal liability, but he can be prosecuted afterwards. The impeachment clause isn't only about the president. I think if Chief Justice Roberts had been less sloppy, he might have included an argument for saying, well, that's generally true, but not true for the president. But he just ignored the impeachment clause. So that's how they did it.
So I do have to, I'm sorry, this is an incredible discussion.
Thank you very much.
Thank you, Professor Dorf.
My pleasure. Thank you all.
Amazing presentation. Thank you all for coming. Thank you for your questions. The next program in this series is October 16th on voting. Spread the news. Thank you.